Welcome to Mayor Brown's Global Financial Markets Podcast. Each 30-minute episode is designed to help listeners better understand the legal issues that impact their business given the ongoing uncertainties in the financial markets worldwide. Speakers from across Mayor Brown's practices and offices provide their timely insights on a wide range of topics, including finance, financial services, and insurance regulatory developments, securitizations, and litigation in the United States, the United Kingdom, Europe, and Asia. We hope you enjoy the program.
Hello, listeners. We chose today's call topic called RESPA Compliance for Lead Generators. Recent CFPB guidance addresses digital comparison shopping platforms, because we will be focusing on the CFPB's recent advisory opinion that addresses online shopping platforms and lead generators under Section 8 of the Real Estate Settlement Procedures Act. We will provide a brief refresher on Section 8's prohibitions. We'll discuss what the advisory opinion says, and we'll highlight some key takeaways and questions that remain based on the CFPB's guidance. My name is Holly Spencer Bunting, and I'm a partner in Mayor Brown's Washington, D.C. office and a member of our Consumer Financial Services Group. My co-presenter today is Associate Kerri Webb, also a member of the Consumer Financial Services Group and also based in our D.C. office. All right, let's get started. Before we dive into the advisory opinion itself, I thought I would like to set the stage on what the RESPA Section 8 prohibitions are to help us understand really the context of the prohibitions that this guidance is addressing. So we're talking specifically about Section 8A of RESPA, and that section prohibits the giving or receiving of a thing of value pursuant to an agreement or understanding in return for the referral of settlement service business in connection with federally related mortgage loans. Now, there are 5 elements that I just mentioned there that all must be present in order to have a violation of RESPA. The first is a thing of value, and that is defined broadly to essentially include any consideration: money, free services, free advertising, trips, football tickets, you name it, is likely covered. The second element is agreement or understanding, and this also is defined broadly. So we don't need a written agreement. We don't even need a verbal agreement. Just an informal wink-wink understanding is enough to meet that component. We also need a referral, and that's something that we're really going to dive into as we talk about the advisory opinion, so we'll talk about that definition soon. Fourth, we need a settlement service, and that's essentially any service that a consumer pays for in connection with the closing of a federally related mortgage loan. And then the federally related mortgage loan, of course, is essentially any residential mortgage transaction. It could be a refinance, a purchase, it could be a HELOC transaction. So it, again, is defined very broadly. If all 5 of those elements are present in a particular business arrangement, then you have a violation of Section A of RESPA. When Congress enacted RESPA in the 70s, it did at least provide some exceptions to permit payments to be made between or among parties that refer business to each other. One of those is famously the affiliated business exception, which allows companies to own ownership in another business and receive profit distributions. We're not going to talk about that one today. Instead, we're going to talk about the Section 8C2 exemption, which allows for fair market value payments for goods or services provided. So if you look specifically at the language in the statute, it says nothing in Section 8 shall be construed as prohibiting the payment to any person of a bona fide salary or compensation for other payment for goods or facilities actually furnished or for services actually performed. So when you break down that services exception, we're really talking about 2 parts, both of which need to be satisfied in order to take advantage of that exception. So the first part is you need goods or services. Those goods or services must be actual, they must be real, they need to be necessary, which means they need to be useful or meaningful to the parties, and they need to be distinct, meaning that they should not be provided elsewhere in a transaction or already paid for. So that would be the first part. The second part is you need a fair market value payment for the goods or services. And essentially that means the payment must be commensurate with the value of those services. Any payment that is in excess of fair market value is considered to be a referral fee in violation of Section 8A. So if you're relying on the 8C2 services exception to justify a payment among settlement service providers, fair market value is an incredibly important measurement to meet that exception. So prior to the advisory opinion from the CFPB, it's been a while since a regulator that's responsible for RESPA has issued guidance relevant to lead generation as it relates to the Section 8C2 exemption. We can go back to 1994 when HUD, when they were responsible for RESPA, used to issue informal advisory opinions or advisory letters where they would comment on a series of factual circumstances. And one of those letters in 1994 addressed the sale of customer lists. And as you can imagine, in 1994, we're literally talking about a piece of paper with handwritten names of consumers that visited an open house, for instance. In that advisory letter, HUD basically said that you can sell those customer leads or those lists of names, provided that the payment for the list reflects reasonable value, that it is not conditioned on the number of closed transactions, and that there has been no endorsement of the purchaser of the list by the seller of the list. And that is guidance that I think anyone involved in lead generation has tried to continue following all these years. The second piece of guidance that HUD issued also in the 90s, in 1996, they published a policy statement in the Federal Register regarding computer loan origination systems. And that policy statement defined a computer loan origination system as a computer system that is used by or on behalf of a consumer to facilitate a consumer's choice among alternate products or providers. And importantly, in that policy statement, HUD identified the service that a computer loan origination system performs as making information about products available to consumers so that the consumer comparison shop. And then HUD, of course, took the position that a CLO could be paid a reasonable fee for that service. So that, again, the providing of information or making information available about a provider's products to allow the consumer to comparison shop. That's the service under Section 8C2 that HUD identified as a legitimate service, and for which a computer loan origination system could be paid fair market value. But HUD also warned in that policy statement that listing only one provider with basic information about that provider's products could be a referral and not a compensable service. And then in addition to that, and this is where we really get into the definition of referral, HUD also indicated that to the extent that one provider is highlighted or is favored in a way such that a consumer may be affirmatively influenced to select that provider, that constitutes referral activity. The definition of referral under RESPA is any action that's directed to a person that has the effect of affirmatively influencing the selection of that provider. So in the CLO context, HUD essentially was providing examples or distinctions about how providers are presented or information about these providers is presented that either is neutral and thus is not a referral, or is presented in a way that could affirmatively influence the consumer. And of course, to the extent that there's a referral present, then you cannot pay for that referral or else you're in violation of RESPA. So for 27 years, that's essentially the guidance that settlement service providers have had to go on as technology has become a major part of how consumers are acquired. We've had outdated guidance to help guide the industry about putting together shopping comparison lead generator platforms that would comply with RESPA. But the CFPB has now provided some guidance in the form of an advisory opinion, and I'm going to turn it over to Kerri to cover what that advisory opinion says.
Thank you, Holly. So as Holly said, the CFPB has finally weighed in on this issue. On February 7th, 2023, the Bureau issued an advisory opinion addressing how it interprets RESPA and Regulation X in the context of digital mortgage comparison shopping platforms. This is the 9th advisory opinion issued by the CFPB since the Bureau put its advisory opinion policy into place in November 2020. The CFPB has stated in its advisory opinion policy that it provides those opinions as guidance in cases of regulatory uncertainty. In those cases, the CFPB can choose to issue an advisory opinion on its own or in response to a specific request. Here, the CFPB appears to have issued the advisory opinion on its own, unconnected to a specific request. The advisory opinion on digital mortgage comparison shopping platforms addresses the applicability of Section 8 to operators of digital technology platforms that enable comparison shopping and generate leads related to mortgage products and other settlement services. The advisory opinion is not really a guide on how to comply with Section 8, but more of a description on how a platform operator may violate Section 8 through particular conduct. The advisory opinion identifies 3 factors that, if met, could result in a RESPA violation. The first is if a platform non-neutrally uses or presents information about one or more providers. Second, the non-neutral information steers the consumer or otherwise affirmatively influences the consumer selection of a provider. And as Holly mentioned, under the prior HUD guidance, steering or affirmatively influencing a consumer selection of a provider is a referral under Section 8. The third factor is whether the platform receives a payment or another thing of value that, at least in part, is for the referral activity rather than for compensable goods or services under Section 8. In the advisory opinion, rather than completely reinvent the wheel, the CFPB applied the principles and guidance from that HUD 1996 policy statement on CLOs. Using the policy statement's definition of CLO that Holly discussed, the advisory opinion states that digital mortgage comparison shopping platforms are a type of CLO, and that the policy statement applies to them. So the advisory opinion uses a few examples to illustrate the 3 factors that result in a violation. All of these hinge on the non-neutral use or presentation of information. So what exactly constitutes the non-neutral use of information? According to the CFPB, non-neutral use of information may consist of manipulation or biasing of the inputs or formulas the platform operator uses to generate comparison options that are presented to the consumer. The CFPB says this conduct is an implied endorsement because it leads the consumer to believe the platform did a behind-the-scenes analysis to identify the most suitable lender. In reality, an operator may violate Section 8 if the inputs or formulas are actually manipulated to show or emphasize particular lenders based on non-neutral criteria, such as the compensation a lender pays to the operator. The CFPB also describes the non-neutral presentation of information as the visual presentation of information that sets certain providers apart from others, such as through the listing order or providing varying amounts of information about certain providers. The CFPB says that this non-neutral presentation can steer a consumer or exert an affirmative influence on the consumer to choose the emphasized provider, which would constitute a referral. Non-neutral user presentation goes beyond the service of having information about the provider's products made available to consumers for comparison with the products of other settlement service providers. The operator must also receive a payment for steering or influencing the consumer. In other words, the violation occurs if the operator is receiving a payment for making that referral. And it may be helpful to think of this like direct-to-consumer marketing. The activity can't be permissibly compensable under RESPA because the activity is a referral. Using or presenting information in a non-neutral manner could also implicate UDAP prohibitions in addition to RESPA violations. For instance, if the platform misrepresents the accuracy of the information presented, it could be considered deceptive. The CFPB specifically points out in the advisory opinion that any such deceptive misrepresentation could accentuate the affirmative influence on the consumer. In the advisory opinion, the CFPB included 5 main examples of conduct by a digital mortgage comparison shopping platform that could violate RESPA, and these are pretty informative. First, the CFPB discussed pay-to-play and steering to the highest bidder. So anything where the mortgage platform provider is boosting the rankings of providers that pay more by skewing results or manipulating formulas, when objectively the criteria would otherwise favor a lower paying provider. It also includes things like presenting providers in a biased way, like by providing web links only for higher paying providers or listing only higher paying providers on the first page of results and lower paying providers on the second page of results. The conduct could include conduct where providers seem to be ranked based on neutral criteria, but the providers are actually ranked based on how much they are compensating the platform operator. The second example the CFPB mentions is payments only from and the promotion of lenders who rotate in the top spot. So allowing a consumer to input information to generate rankings, but the mortgage platform provider actually permits all providers participating on the platforms to take turns appearing in the top spot, either randomly or on a schedule. So the ranking is not actually based on any of the information input by the consumer. The third example the CFPB gives is preferencing platform participants that are affiliates, and that may be done through manipulating rankings to place affiliates at the top of the website rather than non-affiliated providers. The fourth example the CFPB provides is additional services that promote certain platform participants. So for example, after a consumer's input criteria that generates a neutral ranking, the platform operator then sends the consumer a message or email that encourages the consumer to submit an application to a particular provider because the provider would be a good fit for the consumer's needs, but that provider has actually compensated the platform operator for that service. The last example the CFPB provides is a warm handoff, where after the consumer inputs information specific to the consumer's needs, maybe such as a credit score or a loan amount, the platform provider transfers the consumer to a particular lender with a message that the consumer may be in good hands, where that provider that the consumer is transferred to is maybe merely the first to respond to an alert about an available consumer and is not based on whether that provider can actually meet the consumer's needs. So I'll now turn it back to Holly for her insights on this advisory opinion.
Thanks, Kerri. So I actually wanted to highlight a couple of the takeaways from this advisory opinion. And in many ways, while the examples here are very good to lay out those types of arrangements that would violate RESPA, they do raise a lot of questions. There's certainly some takeaways here that are helpful in reevaluating your lead generation arrangements, but I think, again, there's additional questions to ask that the advisory opinion doesn't necessarily help us with. One of the things, though, that I wanted to start with is the advisory opinion is is pretty clear that the CFPB believes that presentation of only one lender or one provider would be problematic, that in and of itself would constitute a referral. That is consistent with what the CLO policy statement said. There's been this myth in the industry that if a lead generation website or shopping platform presented 3 or more providers, that almost acted like a safe harbor. That doesn't actually come from the CLO opinion. There's no statement in there that suggests that 3 or more is a safe harbor in terms of avoiding the indication of a referral. But we at least have guidance from the CFPB that 1 doesn't work, but they decline to provide a specific number that does work. So really, we're in the same spot that we've been in all these years, which is if a lead generation website generates a list of 3 lenders, is that enough? Does it need to be 5 lenders? What if it's 10 lenders? What if it's only 2 lenders? So we don't really have an answer to that question. And again, I think the takeaway is the more lenders or providers that appear in that list, then the better you are being further away from being deemed to have made a referral. So Kerri also highlighted as one of the examples that the CFPB addresses warm handoffs. This is something I think that has come up a lot as it relates to lead generation is, once a consumer gets a list of providers, there's that extra service, that extra offering of being able to connect them to a provider on the list and whether or not that creates an issue. Interestingly, the examples that the CFPB uses in the advisory opinion, both are situations where the platform that's transferring or handing off the consumer never names the lender. So if the platform had said, Mr. Consumer, thank you for your information, I'm now transferring you to ABC Mortgage, I think in that situation, there's no question that by naming ABC Mortgage, the platform has made a referral. And if ABC Mortgage is paying for that transfer, then that creates a RESPA issue. But the examples in the advisory opinion are 2 situations. In one case, the platform transfers the consumer to a lender and merely says, this lender will take care of you. When in fact, as Kerri mentioned, they're just handing off to the first lender that responds to the inquiry. Or the platform would say, enter information, Miss Consumer, about what your needs are, and we'll transfer you based on the information you've provided. Again, they don't name a particular lender, but the consumer thinks they're being transferred to a lender who best meets their needs based on the information that they've inputted. In both of those situations, the CFPB suggests that there is an implied endorsement that by suggesting the lender to whom the consumer is transferred is best to meet their needs or is a lender that responds specifically to the consumer's information, that there is that implied endorsement or affirmative influence on the consumer's selection. So that truly makes it difficult. I think if the takeaway from that is, well, what if you don't imply that a lender is best for the consumer's needs? And what if you don't first ask the consumer to enter information before they're transferred to a lender and you don't name that lender either? Is it still a referral, or is that a situation where a warm handoff might be compliant? And I would say that it's still a tricky situation, that to the extent that you are directly connecting a consumer to a particular company, even if you don't name them or provide them with any boost in the way you describe them, I think there's still a concern that the consumer could see that as an implied endorsement. So interesting that the CFPB focuses on warm handoffs. I do think that is a tricky situation from a services perspective. Another thing that the CFPB focuses on in the examples that they give is the fact that lenders are paying different amounts for leads. and whether or not that's based on different services, or are they paying more because they're actually paying for a referral? And so I think that really highlights the importance of being able, with these platforms, that to the extent that lenders are going to pay at different amounts, that's based on a different menu of services. So whether it be the actual service of providing the information, everyone's paying for that. But perhaps there are lenders that are also paying for the platform to mine particular data, or to directly integrate the technology into their own technology such that consumer information can be passed through more quickly and more efficiently. And so that's the additional service or add-on that the lender pays for. I still think it's fine for a lender or another provider to pay for those additional services and thus pay a different amount. But again, I think this advisory opinion highlights the fact that to the extent that lenders are paying or providers are paying different amounts for leads, that there really needs to be based on a clear delineation of what the different services are that those providers are paying for. The other thing that we're seeing as a result of the advisory opinion is the technology platforms that are out there, as well as the settlement service providers that participate with them, are really reevaluating how the platforms work, as well as what the compensation structures look like. When you really focus on the language of the opinion, it's talking about the operators that are violating RESPA. But of course, making a payment is considered an equal violation, the giving or receiving of a thing of value. So even though the advisory opinion is focused on the conduct of the platform, to the extent that you are a provider that is paying one of these platforms, you of course want to be comfortable that what you're paying for is in fact a service that's compensable under RESPA and is not a referral. So if we think about it in terms of if you're a lender or a title agency or another provider that's paying for customer leads through one of these comparison shopping platforms, what do you need to do to really evaluate whether or not you're in compliance with this advisory opinion? Kerri talked about the fact that the advisory opinion really separates its examples into two different types, one being a non-neutral use of data, and the other being a non-neutral presentation of information. So if I'm a title agency that's paying for leads from a particular website, and that website has created a formula that highlights other title agencies that pay the most, as opposed to highlighting title agencies based on the highest to lowest settlement fee, as an example, how am I supposed to know that if I'm a title agency participating in that platform? So I think providers that are participating are at a bit of a disadvantage to be able to really get the information they need and understand how these platforms are operating to ensure themselves that there is no non-neutral use of data behind the scenes that's yielding the list of providers that are shown to the consumer. I think the non-neutral presentation of information is a bit easier to deal with. That seems like it's discernible based on what you see on the website itself. So for instance, if the provider at the top of the list is always highlighted in yellow, or the provider at the top of the list always has a direct link to their website and no one else does, and there's additional compensation that's being paid for that type of emphasis, it's going to be a lot easier to take a look at the website and be able to determine whether or not there may be some non-neutral presentation of information that's occurring that would then lead to the RESPA concern. Another thing that Kerri highlighted as we're sort of wrapping up our discussion here is that the platform itself could be completely neutral. It could present information in a non-neutral way, but there could be additional services that cause the violation. And so the example in the advisory opinion is a situation where a provider has paid for a lead, but then they've also paid for the platform to send a particular email to the consumer and introduce the consumer to that provider. In some ways, it's a bit like a warm handoff, except that in this situation, really you've paid the provider for a little extra marketing of a particular lender. So even if the payment for the lead itself is perfectly acceptable based on the services exception and the neutral presentation of information, if the provider then also pays for that email, that marketing email to be sent, that's where the violation crops up, because the communication and sending of that email is an affirmative influence on the consumer to pick that particular provider. So again, don't just stop at the platform service and presentation of providers. Also consider what those extras are and whether or not those extra services also could be their own violation. This is an advisory opinion, again, that I think folks are going to be talking about in industry conferences and webinars and other sessions that are coming up this spring, and for good reason. There's a lot of questions, I think, that remain here. I think there's a lot of ambiguity about how providers are supposed to navigate doing compliance checks on the platforms that they participate with, and being able to assure themselves that what they're paying for is in fact the service and isn't in any way being used to affirmatively influence the consumer, which again is what creates the RESPA issue. So lots of issues here. We could talk about this, I think, for another half hour and not really cover it all. But at this point, we're out of time. Thank you to our audience for listening. Listeners, if you have any questions about today's podcasts or anything else that's related to the global financial markets, please email us at gfm@mayorbrown.com. We look forward to you joining us on another Mayor Brown GFM podcast. Thank you.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayor Brown audio programming, visit mayorbrown.com/podcasts. Thanks for listening.